The officer had declined to testify in criminal court, where assault needs to be proven beyond a reasonable doubt, a higher bar than a civil offense. Wow! The officer didn't testify? That's crazy. Defense argues that either Sumrall stepped back on her own flag, or Ali's shawl, called a keffiyeh, entangled with the flag accidentally. Oh man, so is the keffiyeh gonna be a symbol too of the Palestinian people? I don't know.
To people in my party, I'm tired of this crap. Israel is our friend. They're the most reliable friend we have in the Mideast. They're a democracy surrounded by people who would cut their throats if they could.
Precedent being established on the Israeli flag? Is that what's happening right here? We got case to dig into, because this legal group is now hailing this as a breakthrough. They're saying that a federal judge in the United States is equating the Israeli flag with Jewish identity. People are starting to say, well, wait a minute. Does that mean that you can't criticize or burn, for example, the Israeli flag if that's discriminatory? Or what are the overlaps here between this judge's decision and free speech rights in America? Now, we'll go through this, but the organization that brought this lawsuit is this organization. It's called the National Jewish Advocacy Center, and they file a lot of lawsuits on behalf of, I think, Jewish people, leverages its experience, expertise, and our nation's legal system to combat the rising epidemic of anti-Semitic activity. And we ask ourselves, of course, what is the difference, or what is the line between free speech and anti-Semitic activity, and how does it work in practice? But here's more about the organization. Now, the National Jewish Advocacy Center offers legal and policy support to Jewish people in the U.S. The guy who founded it is called Mark Goldfeder. And after 10/7, the NJAC sued several American organizations that it says aided Hamas on behalf of the victims of the attack. They sued the AP, they sued the AJP Educational Foundation, they sued the National Students for Justice in Palestine, and they've also sued this person, Janine Ali, right here. We're going to go through the complaint. We'll see what the judge ruled on this, because this came down out of the District of Columbia from a judge called Trevor McFadden, granting their injunctive request. But this organization is a legal and public policy group. The center says that in the history of persecution and the need for formal defense, we must ensure that the Jewish narrative shifts from defensive to inspirational. Now, the organization works with state legislatures to pass what it calls challenge-proof bills that align the First Amendment to fight anti-Semitism. What? On college campuses and elsewhere. The organization uses the International Holocaust Remembrance Alliance definition of anti-Semitism to modify our First Amendment challenge-proof bills that just align the First Amendment? What? The center provides courses for lawyers around the country on how to fight anti-Semitism. The content includes learning the international law and the law of war with relation to Israel self-defense. It also collaborates with Christian groups to educate clergy about anti-Semitism. Yeah, we know. So Mark is the CEO, founding editor. He's taught law. The 10/7 attacks happened, and they've been filing a bunch of lawsuits. We've got one queued up right here. But they're celebrating this, and I just caught wind of this because the Times of Israel was posting this story August 14th, referencing a ruling that came out a couple weeks earlier, and they say that a federal court says attacking the Star of David is racial discrimination. It's not political protest, okay? So it's not free speech. You can be sued civilly for that. You can be the subject of a lawsuit and not have First Amendment protections because it's racial discrimination, is the allegation. Setting a legal standard, right, they say, for future cases involving anti-Zionist targeting of Jews, right? Now, here's what they write, Times of Israel. A Jewish legal advocacy group hailed a legal breakthrough in court battles in America against anti-Semitism after a U.S. federal judge last week equated the Israeli flag with the Jewish race, right? The judge's decision sets a new legal standard that can be used to protect Jews targeted in anti-Zionist attacks, said this organization, the National Jewish Advocacy Center. Pro-Israel Jewish activist, her name was Kamara Sumrall. She filed the lawsuit. Sumrall alleged that she was attacked at a pro-Israel demonstration, which is already illegal, right? You can already sue somebody for that and charge somebody with a crime for that, right? For attacking you. An anti-Israel activist at the protest approached this woman, yanked on her flag, and choked her. So that's a problem, right? That's illegal. A police officer arrested her, witnessed the incident, and arrested her. Okay, so she got charged with assaulting somebody, just like anybody else. Okay, pretty standard. The anti-Israel protest was organized by Code Pink, a far-left activist group that demonstrates against Israel. And so both the assailant and the pro-Israel activist regularly attended dueling protests in the Capitol. Sumrall said that she's got death threats. Now, the lawsuit said that the assault was discriminatory, right? So it's a little different than just an assault case. The lawsuit, like others filed by Jewish Israel supporters around the U.S., say that Zionism is a facet of the faith, and it's not a political position. The advocates have used the interpretation of Zionism to protect pro-Israel Jews and to combat anti-Zionism under U.S. civil rights protections that cover religion, race, and national origin, but not politics, okay? So trying to shove your criticism of Israel or the Israeli flag into the other civil rights protections, okay? Religion, race, and national origin. So you can't talk about those things because it's inherent with the Jewish race. The argument has been widely used in cases involving the Civil Rights Act, which bars discrimination in programs that receive financial assistance in places like universities. The lawsuit said Sumrall had been targeted in the attack due to her race, right? So it's not that she is advocating on behalf of Israel and people have some questions about what Israel is doing. It's that she's just a racist, bigoted person saying she's attacking her religion and national origin, which means now you can sue under those provisions and get a restraining order and seek damages. Okay, so sort of this Jewish lawfare group is now compounding and compiling these lawsuits and then suing. In this case, we're going to see this person individually for money damages, calling it a racist thing. Lawyers for the defendant argued that she had been acquitted of the assault charges in criminal court. Wow. The defense said that the defendant's keffiyeh had tangled with her flag when the two bumped into each other at the protest, and there was no malicious contact between the two anyways. The legal team also argued that the lawsuit was conflating honest and widespread criticism of Israel's policies in Palestine with anti-Jewish hate, and this incident was not discriminatory. It's about Israel. The restraining order would prevent the alleged assailant from attending protests, so she can't even go there, they say. She can't go back and protest? What? Violating her First Amendment rights since both women attend the same events on opposing sides. So one side can go, the other side cannot, because one side sued and got an injunction against the other person from showing up, right? And it sounds like the assault claim was thrown out. She was found not guilty of that. The judge in the case, District Judge Trevor McFadden, sided with Sumrall in a civil case, saying that the defendant purposely discriminated against her on the basis of race, right? Not Israel, race. And that she had likely committed battery, citing testimony from the police officer. The officer had declined to testify in criminal court, where assault needs to be proven beyond a reasonable doubt, a higher bar than a civil offense. Wow! The officer didn't testify? That's crazy. In trial, he declined to testify? That's very, very interesting. So since they were unsuccessful there, they just sued in a civil court, and they just said, well, this is racially discriminatory, so now you have to stop her. Now, the defendant did not have reason to think that she was affiliated with the government. Instead, she was attacking her because she's a Jewish person. We got it. So the lawsuit also made use of a novel use of an obscure federal legal provision dating back to the Civil War era aimed at combating racial discrimination. The provision, first enacted in the Civil Rights Act, guarantees equal rights for all racial groups, and Jews have been recognized by the Supreme Court as a race for purposes involving civil rights laws. And so the provision elevates racially motivated assault from the state court to the federal court. Code Pink are the people who are being sued on this. They decried the decision. They said this lawsuit, saying that criticism of Israel's government and his flag, which is a political symbol currently responsible for mass civilian deaths, calling that anti-Semitism, this is false conflation, and it seeks to criminalize political speech, even though many critics of Israel's policies are themselves Jewish. It is an effort to erase the critical distinction between opposing a government's actions and attacking a religion. So now, this person's being sued. Some of the tactics deployed by these Jewish groups, including the National Jewish Advocacy Center, include suing nonprofits that facilitate illegal protest, using a law meant to protect abortion clinics to cover synagogues, and expanding civil rights protections for Jews to new areas such as sports venues, and apparently much of it in an attempt to properly align the First Amendment, which isn't good enough for them. So they have to change it to better suit their endgame. So what we're seeing is just lawfare from Jewish law groups trying to gain an advantage in the courts, and they're winning. You can see here, the District of Columbia, this was the verified complaint, but here's what they said originally. Plaintiff Kimera Sumrall now sues for violations of her civil rights and common law battery, trespass to chattel, intentional infliction of emotional distress, wants damages because these two people were protesting and the other person was not even found guilty of anything. Plaintiff seeks to recover monetary damages, attorney's fees, and injunctive relief, saying, here's what the background. Now, plaintiff Kimera Sumrall is a Jewish resident of DC who was physically attacked, they say, this is their complaint. Defendant Janine Ally is a natural person who physically attacked plaintiff. So here's the background. So the Jewish person who feels and publicly expresses a deep affinity for Israel, her ancestral homeland, that's who she is. She identifies Israel as her ultimate place of national origin, and her racial and religious identities as a Jew are also intimately connected to Israel. Wow, it's like amazing. It's like, why isn't she over there? Plaintiff's connection to Israel Israel is neither idiosyncratic nor can it be chalked up to mere politics, is at the core of what makes her and millions of others Jewish. The Bible itself references this ancient Jewish hope for the return to the Jewish sovereign homeland. Yeah, you can go. From the Jewish law perspective, over half of the biblical commandments that Jewish people are bound to obey, blah, blah, blah. Indeed, the Jewish religion is predicated on God and the chosen people and all the things. And the attack happened. Now, plaintiff attended a small pro-Israel demonstration at the U.S. Capitol. Plaintiff wore an Israeli flag tied to her neck as a cape. The Israeli flag is blue and white, symbolizes a distinctive design of Jewish prayer shawls, and is emblazoned with a large Jewish Star of David, both exclusively associated with Jews. The defendant was also at the Senate building at an anti-Israel demonstration. When the plaintiff, the Jewish person, was isolated from her group, defendant approached her from behind with her adorned Jewish symbology and yanked on her flag, and it briefly choked her and caused her pain and disorientation. Immediately thereafter, plaintiff witnessed defendant walking away. There were no other persons there beside law enforcement. Plaintiff yelled for the police to come. So a U.S. police officer came over, Reed Bonney. He witnessed the attack. Defendant said to officer, "All I did was grab it," and so Officer Bonney arrested the defendant. And that's basically an admission, right? Why'd you grab her flag? You don't need to do that. So defendant did not similarly attack any non-Jewish individuals at the rally. Did she know that she was Jewish just because she has a flag on? Is that like clear indicator that she's Jewish because she has the flag, like automatically? Or maybe she's just somebody who supports the Jews. Nor did she attack any individual not wearing items associated with the Jewish race, religion, and national origin. Okay? So what about government? What about country? What about nation state? They just forget about all that, right? Because now they're trying to shove this in the civil rights provisions. So defendant's assaults on Summerall left her feeling unsafe, engaging in peaceful support for the state of Israel and the Jewish people. And so based on the defendant's willingness to commit an assault in plain view, and they've seen each other on about 10 prior occasions, they're all, they're out there just screaming at each other about this stupid stuff that's not our problem. Like, they can just go back to the Middle East and just duke it out over there. Why are they duking it out here in Washington, D.C. for all of us to have to deal with? Plaintiff fears for her physical safety if she were again found in defendant's presence. Plaintiff would like to have the option to safely continue to attend rallies to demonstrate her support for Israel in America, an expression of her race, religion, and national origin, and support for a foreign government, at times wearing an Israeli flag tied around her neck. The anti-Israel rally attended by the defendant was organized by Code Pink. They call it a hate group, and we've got no love for Code Pink here. They've got animus towards Jews. Anti-Jewish racism and associated animus, otherwise known as anti-Semitism, is defined by the International Holocaust Remembrance Alliance as the following. And I'm pretty sure it was written by Jews, but a certain perception of Jews, which may be expressed as hatred towards Jews, it's all, illegal now. So this calls for further examples of what is anti-Semitism. We know it's everything now. You can't do anything. You can't even want like FEMA government money unless you're like in love with Israel, or else they'll cut your funds off. That was the old plan. Apparently that's changed. But Code Pink has a history of a bunch of things. Here, as for example, there was an incident egregious enough, it captured the DOJ's attention, and they wrote a statement of interest. And they've been accused of using anti-Semitic and bigoted language in intimidation acts. The violence included the use of bear spray, right? Those are crimes. And media reports shouting things like eliminate Jews, a bunch of bad, nasty things, right? Which are obviously horrific, but you're allowed to say horrific things. We also had another one. This was a spectacle where they dressed up in military fatigues. They put a giant Jewish star on her shirt, okay? The Code Pink founder, Medea Benjamin, and with a fake gun, pushed around an almost naked elderly gentleman while yelling at him in a fake Israeli accent, okay? She was trailed by an elderly woman in a Holocaust-style pajama that said never again. The caption of the video stated, "This is a Holocaust." And I mean, it's bizarre, but that's free speech. Code Pink routinely draws comparison. You can't be really naked, I don't think, in DC, but you get the point. You're allowed to do these things. You can slur. They've linked Israel to the California wildfires. They blamed the Jewish state for a domestic disaster. They participated in a conference in Iran, saying that they're not the only activists with the Code Pink hate group, which alone is not probative. And so a bunch of other things that Code Pink has done, which are bad, right? Plaintiff attended a court hearing in support of this rabbi, and they glared furiously at her and other Jews supporting the rabbi, all right? So like there's harassment, man. There's a lot of harassment going on. And now we've got lawsuits flying too. Okay, so battery, trespass to chattel, prayer for relief, and more. What they want is they want compensatory damages. They say that this person has had physical pain, emotional distress, loss of enjoyment. They want punitive damages to punish this person for intentional and malicious conduct. And they want an injunction so that this person cannot be near them, remaining 5 yards away, 100 yards from the home, and other things, signed by the Jewish Advocacy group. So that goes in. in. Then we get the District of Columbia coming out, issuing a 20-page ruling. And here's what this one looks like. This came down from Judge Trevor McFadden. And the important thing, we want to be clear about as we're reading this, and I want to be fair on this, is whether statements like this are true or not. Okay, this came over from Sean King. You know who he is. He was that, I don't know what race he is, but he's not a fan of Israel. Let's just put it at that. But he posts stuff like this. The Israeli flag just became the only national flag illegal to burn in the United States. Yeah, I'm dead serious. And I don't think that's exactly right based on my initial read. But again, the point is that they're saying that this is kind of a stepping stone into much broader civil rights protections that might make that illegal, right? Make that like an attack on race, like, burning crosses or something. So federal courts are saying that this is going to set a legal standard for future cases. And the question is, are we there yet where it's illegal to burn an Israeli flag? I don't think so. But here is what we've got coming down from the judge. Plaintiff Kimmorah Sumrall and defendant Janine Ali frequently attend protests about the war in Gaza because they just got nothing better to do than to cause a ruckus in our country. The problem is that they're on opposite sides. Last fall, Sumrall proudly displayed her Jewish heritage at a protest. She tied an Israeli flag around her neck, writes the judge. She alleges that Ali approached her from behind and yanked it, choking her. Now they write, if speech provokes wrongful acts on the part of the hecklers, then the government must deal with those wrongful acts directly, right? You punish the acts, not the speech. Sumrall asked for a modest stay-away order against Ali so that she feels comfortable continuing to attend the pro-Israel protest and counter-protest, and the court grants her request. On November 13th, here's what happened. 2024, they were on opposing sides of a protest about the war in Gaza. An advocacy group called Code Pink planned to lobby in favor of the Palestinian causes in the Dirksen Senate building that day, committing an insurrection. Code Pink invited Ali to join. Now, the group's members gathered in their characteristic pink attire in the Senate cafeteria. As they assembled, Sumrall arrived to attend a pro-Israel protest that had been organized in response to the Code Pink demonstration. Okay, so the Code Pinkers were there first. Then they came in response. She wore an Israeli flag as a cape tied at her neck with a nylon twine. Several U.S. Capitol Police officers were also present. Now, the parties agree at least about the actors' basic movements before the incident. Sumrall was the first in the cafeteria, standing at the top of the crowd ramp with the officers. She was talking on her phone, this Jewish woman. Ali was running late to meet her protest group, so she walked alone towards the ramp to meet him. Now, Capitol Police Officer Reed Bonney was standing nearby, about 5 to 8 feet away, facing the Jewish woman, Sumrall. Ali passed close behind Sumrall on the ramp. Now, this is where the agreement ends, right? So they say she's just walking by, the other lady's on the ramp, she's got the Israeli flag hanging off the back. Here's the story. Officer Bonney testified in the criminal trial, so he did testify, that he saw Ali walk behind Sumrall and grab an Israeli flag that the victim had wrapped around her neck. So he did testify. He added before this court that he could see most of Ali's body from the vantage point in front of Sumrall. Specifically, he could see her right hand, which was empty, as it grabbed the flag and yanked it downward. He described the interaction as a simple assault. It was not accidental, right? Yeah, can't do that to somebody. Kimmorah reported feeling someone yank her flag behind, jerk her back, choking her, though she could not see who did it. So she said she looked around to see only police officers and Ali walking away. Officer Bonney said that Kimmorah had an immediate clear reaction, yelling for the police to arrest Ali. Now, Ali claims she did nothing wrong. It would have been impossible, she says, because she was holding her phone in her right hand, the one closer to Sumrall, after calling her group to meet them. Plus, a disability prevents her from using all of her fingers, so she could not have grabbed the flag while holding the phone. And her left hand was similarly occupied with her purse. Now, a relative of a Code Pink demonstrator testified that she saw no contact between the two women as Ali passed on the ramp. Defense argues that either Sumrall stepped back on her own flag or Ali's shawl, called a keffiyeh, entangled with the flag accidentally. Oh, man. So is the keffiyeh going to be a symbol, too, of the Palestinian people? I don't know. What happened next is also disputed. Officer Bonney followed Ali into the Code Pink group and pulled her out to arrest her. He testified that as he was bringing her out of the group, away from the group, she said, "All I did was grab it," okay, which is an admission. Ali claims that she was not wearing her hearing aids that day. So in response to the officer's question about whether she pulled the flag, she responded, "I pulled it?" Officer Bonney clarified, wonder if there's body cam, that he did not ask her a question to elicit a response. He says that she spontaneously spoke as they were walking from her group. Now, so obviously the officer's testimony is going to be a lot more credible than hers. Now, Sumrall says that since the incident, she is feared for her physical safety, the Jewish woman. 10 days after the first hearing in her civil case, she alleges she received a threatening phone call, which is also a crime. Threatening and intimidation, can't do that. Sumrall also lives with the threat of future encounters because Ali still participates in the pro-Palestinian protests protest, and Sumrall would like to attend as a pro-Israel counter-protester as well. It's like, oh my gosh, don't you have anything better to do with your lives? You have to come to our country and then scream at each other about your foreign conflicts in order to move our politicians to care and get invested in your foreign conflicts. Sumrall says that the Code Pink rhetoric at these rallies heightens the fear of, and they both like, we have to go fight with each other. For example, in March, she alleges unrebutted that Ali attended a public event where individuals dressed in Israeli flags picked up bloody dollar bills thrown at a costumed Uncle Sam. The parties effectively agree that the two women want to attend the same protest. They're going to cross paths again. So they sued. Sumrall filed a civil case and got a temporary restraining order. Then the United States filed misdemeanor assault charges. While the stay order was in place, Sumrall did attend at least one event as a pro-Israel protester, while the other lady couldn't come there. She says that she felt comfortable doing so because Ali was not there. Sumrall was indisputably obstreperous towards the host who testified before this court. Now, a few months later, Ali was acquitted of simple assault after a criminal bench trial. Not guilty. Shortly afterward, the state's civil case was scheduled for an evidentiary hearing about whether to extend the civil stay-away order. Sumrall struggled to summon her main witness, Officer Bonney, to testify. So there was another trial that the officer didn't show up to. Okay, that makes a lot more sense. Like, an officer is going to show up if a prosecutor is asking them to be there for a prosecutor's trial. Cop's going to be there. So at the criminal case, cop showed up. At the civil case, where the Jewish woman was trying to extend her order of protection, essentially, cop wouldn't show up there to testify. Now, as a federal officer, he had sovereign immunity to that court subpoena. He didn't waive. She fought a federal subpoena from a different judge, but the judge declined to issue a subpoena to him either. So about 1 week later, right, then she filed a complaint before this court. The court granted the TRO, and here we are. So Sumrall, the Jewish woman, represented that she was going to voluntarily dismiss her case. It has since been dismissed in the Injunction case because she's got it over here, basically moved it from there to here, and the judge says that's the background. So now I need to decide what the rules are. And he says she wins. And again, we're asking about racial discrimination and how that interplays. Sumrall has carried her burden to receive this injunction. First, she's shown that she's going to win because there is cognizable danger here. Now, before turning to the dispute itself, we have to address Ali's doubts about the court's ability to even hear this case, saying Ali says the court should dismiss the case because the hook for jurisdiction, saying this is a civil rights claim, is pretextual, saying the courts must guard against attempts to sneak state law claims into federal courts through ginned up federal grievances. But beyond this, her claim is exaggerated and specious. They say Ali is given, besides that, they say they've given no reason to question the legitimacy. She says this was racially discriminatory battery, and we have no doubt that she's sincere in invoking federal law. Then they say voluntarily abstain, and basically these are some procedural arguments, right? These are claim precluded. She's already made this case elsewhere, and so she can't bring those claims here. The judge is going to get rid of those and say, here, Sumrall already dismissed the other one, okay? So it's actually not an overlap, and there's no conflict here. And regardless of claim splitting, Ali forfeited that by failing to mention it in her initial brief, and so this case can move forward here. But setting that aside, the court has jurisdiction, and so here's what they write. Sumrall, the Jewish woman, has shown that she's going to win on the merits of her Section 1981 claim. The statute says, all persons within the jurisdiction shall have the same right in every state and territory to make contracts, to sue, to be parties, give evidence, and more, as enjoyed by white citizens. Now, Congress enacted this statute back in 1866. It was a post-Civil War statute ensuring that newly freed slaves get the same rights as other citizens for the slaves. Now, the provision protects racial minorities from private acts that infringe on their rights to contract, sue, or otherwise enjoy full and equal benefit of the laws. The statute only reaches purposeful discrimination. That was the but-for cause. Without that discrimination, it wouldn't have occurred. So he's filing this claim, right? It's an old Civil War claim. To make out a claim under Section 1981, you must demonstrate that this person was treated differently than others who were similarly situated, too, because of his race, not because of an Israeli flag, but because of a person's race, which in this case is Jewishness. Now, that discrimination must have affected the individual's full and equal benefit of the law. Now, the DC Circuit uses this test to decide how it works, but we don't discuss this when there's direct evidence of discrimination. Now, the parties in this case contest whether Ali purposely discriminated against Sumrall. Okay, maybe she's just unhappy with Israel, walked up, yanked an Israeli flag because she's unhappy with the Israeli government. That's assault, fine. Is she liable under slave civil rights type laws? And two, whether that action deprived her of all equal benefits of the laws for the security of persons. Now, neither side questions whether Sumrall is part of a racial minority within the meaning of the statute, because the Supreme Court has said Jews are a racial minority. This is a 1987 case that are protected by this. And so the court takes each dispute in turn. First, the Jewish woman Sumrall has sufficiently shown that Ali purposely discriminated against her on the basis of her race, not the flag. A preponderance of evidence says that she committed the batteries. Again, this is not a criminal case, so it's not beyond a reasonable doubt. It's 51% more likely than not. Officer Bonney's testimony described the event in detail, how Ali committed it, that Sumrall reacted strongly, clearly, and immediately. He testified that Ali confessed her behavior as he arrested her. Having considered Officer Bonney's demeanor, the court finds him to be highly credible. He was the only neutral witness, and Meredith, who testified for the defense, she supports Code Pink, so his officer's credibility is higher than hers. To credit Ali's version of events, we'd have to assume that both the officer and Sumrall were lying, and they're not. Now, granted, as Ali argues, the Superior Court acquitted Ali of simple assault because the evidence did not rise beyond a reasonable doubt. But this court evaluates this at a lower standard, and that is an interesting one. So I'm sure that was a bench trial, so the judge just acquitted her. After weighing all the evidence before it, the court discredits Ali's evidence that contradicts officer's testimony. So the court says, even though she was acquitted, I find that she committed battery, which was harmful or offensive touching of another. Now, the evidence shows, at minimum, an offensive touching. That is when the yank happens. Okay, so that's a regular claim. You can have that all day. But to be sure, a different outcome may be required after discovery. Based on the evidence currently, I think she'll win. And the battery is direct evidence of discrimination that would not have occurred except for her racial animus. Saying, we're looking at evidence. Purposefully yanking an Israeli flag tied around a Jewish person's neck. Does she know she was Jewish? What if you pull an Israeli flag around a non-Jewish person's neck? Does that matter? To choke them is direct evidence of racial discrimination. How is that direct evidence of that? The Star of David emblazoned upon the Israeli flag symbolizes the Jewish race. Star of David, Encyclopedia Britannica, he's citing, battery involving a racial symbol is strong evidence of racial discrimination. It is more severe than racial slurs or statements. And the targeting of the Star of David is as racially motivated as the highly offensive slur, the N-word, which constitutes direct evidence. So Ali has said there's no interpretation, benign interpretation, of choking her, and it's hard to imagine one. Her closest argument is this one, saying, well, the Israeli flag represents the state of Israel rather than the Jewish race, doesn't it? So her action is merely anti-Israel, not anti-Semitic. Yeah, that's pretty obvious defense there that a lot of people share. He doesn't pay much mind to it. But it is quite a stretch to say that yanking on a flag tied around someone's neck is an objection to state policies. Battery is not a legitimate form of protest. Of course not. Well, it's a crime. That's why you charged her with a crime. Now, as Sumrall's counsel stated, now Ali did not have reason to think that Sumrall was affiliated with the Israeli government. No, but she was advocating for their actions, clearly. Rather, it is much more likely that she was intentionally attacking a Jewish person wearing a Jewish flag as a symbol of her racial heritage. And so as Sumrall counsel contended at the preliminary hearing, if yanking on a flag emblazoned with the Star of David tied to a Jewish person's neck at a pro-Israel protest is not discrimination, I don't know what is. And so finally, Ali says that the pleading of a state tort is not enough to show that she was deprived the equal benefit of all laws. What does that mean? But Ali's cited cases don't provide any additional evidence. And so we think that these actions would not have occurred but for racial discrimination. And for these reasons, the court holds that she'll win. And she's also shown that the relief is going to be narrow. All right. So is this judge saying you cannot burn Israeli flags? We'll see. But Sumrall alleges two forms of harm. She says, I have discrimination against me and I have a fear of physical assault. Sometimes courts have determined that being subject to discrimination itself can be irreparable harm. And we already know that Ali is likely engaged in this conduct. She has shown no remorse or taken accountability for this, writes the judge. She was acquitted. The parties agree that Sumrall and Ali will be at the same protest again because they're just going to, throw food at each other for the rest of their lives. So the discriminatory harm has a high risk of recurrence. The two women will likely again be at close proximity in emotionally charged events. There will likely be racially discriminatory comments, and they're just going to keep going there. So allegations of physical threats have also shown harm. Sumrall is essentially seeking a restraining order, and he's going to grant it for her. The entire mosaic of the case includes a battery, and after a hearing, a threatening phone call, and more. And since these events, she's installed additional security cameras on her property, bringing her some peace of mind. So finally, the balance of the equities favor a 3-yard stay away order. Okay, so here's what we're going to get. Evidence of past physical harm can tip the scales. Here, there's a history of battery, favors an order against Ali. Its narrowness ensures both women can still be present at the same event. Okay, it's like 3 yards away from each each other? Oh my gosh. The parties are in violent agreement. They both have First Amendment rights to speak their minds. This 3-yard order will accomplish that. There's no history of Sumrall seeking out Ali, though an order has been in place for a while. The public interest favors an injunction. Sumrall has alleged that her fear of repeated battery is chilling her freedom to express under her First Amendment her support of Israel. The government, right? Are they one and the same? There is public interest in promoting free and, unfettered debate. Ali contends that Sumrall's expression has not been chilled. She said, what are you talking about? She's protesting at events at least once since the battery, so it hasn't deterred her at all. There is no irreparable harm. She keeps showing up. So weighing these factors together, the court says, we're going to grant Sumrall, the Jewish woman's motion for an injunction, and here is what it says. The terms of the stay-away order against Janine Ali are as follows. 1, stay at least 100 yards away from Kamara Sumrall's home and place of employment. Have no contact with her by any means whatsoever. Do not communicate or attempt to communicate either directly or through another person or any other mechanism. And this order is in effect immediately and will remain in place pending further order of this court. So Trevor McFadden, the judge, now equating the Israeli flag with racial discrimination and not spending any time at all on this idea, really, it's like a sentence, on this idea that Israel's flag might represent the Israeli government. And so now the ancient laws passed for slaves in America are being perverted to apply to Jewish people who have flags yanked, who are going to protest on behalf of their foreign country, government, race, whatever, in our state capital. But the point is, we've got a lot of pro-Israel support out there. And one person who is sick and tired of, I guess, guys like me who say, well, we actually care about America and the First Amendment, have to think about some of those issues here. Lindsey Graham says he's sick and tired of us.
But tonight, it's late at night, Israel is in a fight for their lives. Our friends in Israel are surrounded by people who would kill them all if they could. I am tired of the word genocide. Let me tell you about genocide. If Israel wanted to commit genocide, they could. They have the capability to do that. They choose not to. Hamas, they would commit genocide in 30 seconds. They just can't. And that's the big difference, folks. To people in my party, I'm tired of this crap. Israel is our friend. They're the most reliable friend we have in the Mideast. They're a democracy surrounded by people who would cut their throats if they could. This is not a hard choice if you're an American. It's not a hard choice if you're a Christian. A word of warning. If America pulls the plug on Israel, God will pull the plug on us. And we're not going to let that happen. So I just want to end with this thought that President Trump has stood with Israel at the most difficult time since its founding. October the 7th was an effort to destroy the state of Israel, the largest loss of Jewish life since the Holocaust. And here we are almost 2 years later, and Israel's the bad guy. That's ridiculous. Israel is not the bad guy. They're the good guy. The bad guys are the radical Islamists who would kill everybody in this room if they could. So I haven't lost my vision of right and wrong. When it comes to foreign policy, President Trump has stood up for all the right things, and he stood up against wrong things.
All right, Lindsey Graham's sick of anybody who questions the alliance, so-called, with Israel. And we've got a bunch of lawfare happening in our states that are now being launched by various, groups on both sides of the aisle on this thing, this conflict. And all of them are trying to pervert our Constitution with new modifications of what it means and how it works. And we've seen this before, okay? And I'm tired of it across the board, whether it's the trans people or the LGBTQ plus or whatever coming in and trying to modify this to be hate speech or laws that are attacking civil rights, all this thing. Tired of it, okay? We have a Constitution, we have a First Amendment, it says what it says, and any attempts to pervert it from anybody, I don't care what race, what color, what religion, what country that you're from, you're gonna get pushback from Americans. And so that's what this is. We'll see what this looks like and whether this does set precedent for saying that you can't criticize the Israeli flag. Of course, we'll keep our eye on it and see.